Florida's Stand Your Ground law is now under a cloud as a result of the controversial February shooting of Trayvon Martin in Sanford, Florida. The 28-year-old shooter, George Zimmerman, who was licensed to carry a gun and once had a brush with police, claims he acted in self-defense after a confrontation with Martin. And some legal experts say Florida's law could protect Zimmerman, who has not been charged. My guest is retired Superior Court Judge from California, Eugene Hyman. Judge Hyman, welcome back.
Thank you.
You have, a perspective on this because you were also a former police officer. Can you talk about really what you know and what you think about stand your ground laws?
Well, under the common law, of course, every person had the right, even before firearms, to defend himself, his or her family, and his or her possessions. Over the years, that's evolved, however, and you have the right to protect yourself and to protect others, but you don't have the right to use force with respect to the protection of property. Now, there are exceptions, for example, with respect to certain laws, fish and game, with respect to protecting yourself against animals, protecting yourself in certain areas of the country if you have animals that are coming onto your property and attacking your livestock, those kinds of things. But when we're talking about human beings, the law generally is very specific in terms of the expansion from the common law. Actually, there's been a retreating movement from the common law in terms of protecting property. We've decided that protecting human beings is one thing, protecting property is another. Now, if someone's coming into your house hypothetically to steal, and you're in that house and you feel reasonable fear, you've got the right to protect yourself, but you're not really protecting your property, you're protecting yourself, and that's an important distinction. When I was a police officer under the law, you could use reasonable force, including deadly force, to apprehend a felon. That is, someone in a stolen car who is fleeing, you would be allowed to use deadly force. That's no longer the case. And when you think about it objectively, do you really want anyone using deadly force with respect to the taking of property? If a police officer can't do it in California, why would a regular citizen be able to do it? Now, we need to differentiate stand your ground in terms of what we're really talking about. Under the common law and under the laws of most states, everyone has the right to protect him or herself and others. You have the right, if you're going to the aid of someone, if you're seeing a citizen that's being battered or hit or at risk, you have the right to intervene and use reasonable force to protect that other person as well. You don't have the right, however, to use deadly force with respect to the protection of not only your property, but the property of others. So that is the usual situation. My understanding of stand your ground with respect to Florida is that you can't use deadly force with respect to the protection of property or with respect to the protection of someone else's property. So if you see someone doing something to someone else's property, you certainly have the right to intervene. You probably have the right to point a deadly or dangerous weapon at them, but in terms of using it if they wanted to flee, that would probably not be covered under the law. And that is the concern in terms of how this is being spun in terms of by the media, that if you're protecting someone's property, you have the right to use deadly force. That is not reasonable.
Mm-hmm. And in this particular case, too, I don't think it's been completely determined that his motivation for killing Martin was protection of property. But, what constitutes threat or harm? Does someone have to have a weapon? In this case, you have a 24-year-old man and a 17-year-old boy with a bag of Skittles in his hand. Even though stand your ground laws might apply here, as a judge, if you're looking at this case, does this child have to have a weapon?
No. Let's say hypothetically you've got a 17-year-old person and they're being assaulted by fists with respect to a much stronger person. At some point, that person probably would be allowed to use deadly force. It depends upon the circumstances. You evaluate the circumstances in terms of the individuals. If they're both evenly matched, and we're talking about fists, probably not. But it would depend upon the circumstances. But I can't foresee a situation where someone's allowed to use deadly force when someone is fleeing. by definition, if the person's fleeing, then you're not reasonably in fear.
Right, and from a police standpoint, if someone is fleeing, I'm guessing the only time when one could justify deadly force is if that person is armed, or they've committed, I don't know, like a murder or something, and you're worried about the safety of others, right?
Right, correct. In other words, I would think in terms of most policies in most police departments today, and you could have a law that would allow something, and then you could have a police policy that wouldn't allow it or would restrict it. So even if hypothetically under state law, if you could use deadly force, that doesn't mean that a police department rule is going to allow it. It would be, as you suggest, a person who's just committed a very serious felony, rape, murder, and they're armed and they're fleeing and they refuse to yield. Then it would depend upon circumstances again. I can't say that there would be a blanket rule that shooting would be okay.
Right, and so looking at this particular case, and just from what you know about it, from even a legal standpoint and a personal standpoint, Zimmerman has not been charged, I guess because they're trying to determine, the self-defense angle of this. What do you think about this case?
It doesn't pass the smell test. You have a young person who's not armed and allegedly is fleeing. What is the risk that the shooter is in terms of assuming giving the best scenario to it in terms of that the juvenile was committing some kind of a crime or even potentially a burglary, a felony? I don't see how that would be justified under any stretch of the imagination to allow the usage of deadly force.
And why hasn't Zimmerman been charged with something at this point?
That's the $64,000 question.
Mm-hmm.
It doesn't make sense to me.
It doesn't.
No,
there isn't
not based upon what I know.
Right. So you would say typically, even though this person has alleged self-defense, most likely in most states he would have been charged with something, and then they would have investigated, right?
Well, yeah, because the question is there probable cause to believe that a felony was committed by this person? Yes, shooting this person while fleeing. And, there would be probable cause, which is not the same thing as proof beyond a reasonable doubt, but arrests are made based upon probable cause to believe.
Understandable. All right, well, Judge Hyman, we appreciate you sharing your expertise again today.
Thank you.
And thank you for watching the Legal Broadcast Network.